Legal dictation start. Therefore, if a person enters into a property as a tenant without a written agreement to that effect, then such a person does not get any legal right qua such property full stop. In absence of written agreement, landlord shall not be a statutory landlord under the Act, and the tenant shall not be a statutory tenant full stop. The status of such a person shall not be even of permissive possession full stop. Such a person shall not be more than a rank trespasser full stop. He shall not be entitled to any kind of protection or defense against the landlord full stop. However, the landlord shall still be having full ownership rights over such property, including his right to uninterrupted possession to the property, being a lawful owner full stop. Hence the landlord shall be fully entitled to ask such a person to vacate the property, and if not so vacated, to throw out such a person without recourse to any legal process full stop. Even if the landlord takes recourse to a legal process, then the court shall also be bound to order restoration of possession without entertaining any defense on the part of any such alleged tenant full stop. Hence, it is only with a written agreement the tenant becomes a statutory tenant under the present Act, and the landlord becomes a statutory landlord under the Act, and both are to be governed by the provisions of the Act, making them entitled to some legal rights and subjecting them to certain legal liabilities full stop. Subsection subclause 2 of section 4, which requires registration of rent agreement, also starts with a non-obstante clause full stop. However, this non-obstante clause is made operable against all the provisions contained in the Registration Act full stop. Before the amendment of the year 2014, even the authority where the rent agreement was to be registered was specified to be the rent authority itself full stop. The authorities under the Registration Act had no concern with the rent agreement full stop. Hence, it was not a document compulsorily registrable under section 17 of the Registration Act full stop. Rather, due to non-obstante clause, it was registrable only under section 4 of the Punjab Rent Act full stop. The provision of section 4 as amended by the Amendment Act of 2014 prescribes that the rent agreement under the Act shall be in the format specified in the schedule to the Act, and the same shall be registered under the and in accordance with the provisions of and with the authorities prescribed under the Registration Act full stop. However, the fees to be paid for such registration has been specified by the provision of section 4 itself, full stop. Hence, it is clear that while subsection subclause 1 of section 4 overrides section 107 of the Transfer of Property Act, subsection subclause 2 is enacted in the nature of overriding the provisions of the Registration Act 1908, except to the extent of same being saved by the language of this very subsection, that is, regarding the authorities with which and the manner in which it is to be registered, full stop.